This is the primal scream of a dying regime.
Pray for our enemies, because we're going medieval on these people. You're just not got a free shot on all these networks lying about the people. The people have had a belly full of it. I know you don't like hearing that. I know you try to do everything in the world to stop that, but you're not going to stop it. It's going to happen.
And where do people like that go to share the big lie? MAGA media. I wish, in my soul, I wish that any of these people had a conscience.
Ask yourself, what is my task and what is my purpose? If that answer is to save my country, this country will be saved.
War Room. Here's your host, Stephen K. Bannon.
Okay, welcome back. It's Friday, 10 July, year of Lord 2026. Momentarily, we'll go to Provo, Utah, to the Charlie Kirk, the fifth and final day of the evidentiary hearing. There's one more witness left. Of course, you heard that the judge said they're going to brief certain controversial issues. That means the briefings are by writing, and then I guess in September they're going to reconvene. Anyway, we'll get all of that worked out on the afternoon show. I think we'll dip in for it. And I want to thank Mo and Grace for doing a fantastic job yesterday. And we will do all that this afternoon, and maybe tomorrow talk about it. But it's going to be September decisions. Metaxas' book when you read it, and I want to tie Michigan, Georgia to Bowling Green. If you go to Manhattan, to the financial district, all the way at the very tip, Battery Park, where the Battery is, and it's called the Battery for a reason, because there was a battery there, and Bowling Green right next to it. When Washington read this, and what's ironic, he kind of started the war officially, because it had been an unofficial, and as John Adams kept saying, we're in open combat in Lexington, in Concord, in the siege of Boston. There's a war, and dragging the cannons from Ticonderoga. We're at war. We're in a shooting war. And so what we need to do is declare that war. All the great thoughts and all of it that touch humanity, and kind of what I call the preamble or the lead-in to the declaration of war, because 2/3 of the document is a declaration of war against the crown, against commons and lords, and against the British Empire and the monopolistic power of the British East India Company and much more, all of it. It's a declaration of war. The first time I think a colony or colony of any scale had actually declared war, independence, because that's leading to war, and this is why this is called the War of Independence, and it's the three phases, the way I look at it. The three phases is phase one is the American Revolution, that whole transition of thinking and thought that led to the Continental Congress and to the Declaration itself, the committee, and Jefferson's thinking and Adams' thinking. But then you transition pretty quickly. Now you're in a formal war. You've formally declared war on the crown, of which they said, because you've gone back and forth, they've told you, hey, if you keep up this is treason. And treason, we're going to hang all you guys. This is why Franklin said it. The power of this is the great leaders and the men of the Enlightenment and the great thinkers and lawyers are magnificent in the setup and all the way through. But there's a time for deep thoughts and great thoughts to give purpose. Because remember, the three phases of war is part one, you have to take the high ground morally and intellectually and spiritually, to give your troops, to give your people something to fight for, something to hang on to. What is it that we're doing here? What is it that we're fighting for? Phase two is to crush the enemy and to get to victory. Phase three is to then leave a smoking crater. Phase three is, as Phil said, smoking crater with your values and your beliefs and your customs and your mores. That process. So they read it out loud on the 8th, and Hancock sent it down to Washington, or sent it up to Washington in New York, because New York is the strategic center. Now, here's what's very important. When he's gathering them on Bowling Green, And he's reading this to them, this very powerful words, particularly the fact that you got this statue that's like Caesar, because it was based upon one of the great statues in Rome. So you've got, I think it's the statue of Hadrian, if I remember correctly. I think it was based upon that. You've got George III looking like a Roman emperor, and people had done this at the end of the French and Indian Wars because of, we won because we were still a British colony and these were British subjects. So you have all these British subjects right there, and they're reading to it. Now, this is not in some vacuum. Like I said, you go to Manhattan, at the very tip, you've got the Battery next to Wall Street, right there, boom, Broadway. You're right there at the very tip, the Battery, and you've got Bowling Green right next to it. Well, what's going on in the biggest, greatest harbor in the world? 300 combat ships and auxiliaries, and 32,000 combat troops and backups, including, I don't know what it was, 5, 6, 7, 8,000 Hessians, who were kind of these mythic savages, like when Caesar tried to cross the Rhine and placate or subject or subdue the tribes in the German forest. Remember the opening scene in Gladiator? Think that, okay? You got these Hessians, you got these brothers that are not known for negotiation. They're known for having a long pike or a bayonet coming at you with a huge hat, scare the hell out of you, right? And all the legends about them. That's in the harbor looking at you. They've come. Here's what they think about your declaration of war. Oh, you're tough guys? This is what you're going to do? You're going to tell us we're the British Empire. We're the British Army and the Royal Navy. The Royal Navy, one of the greatest institutions ever created by man. You're going to tell us, you punks are going to sit there, John Adams, who's John Adams? John Adams and Thomas Jefferson, and you guys are going to tell us what you're going to tell the king, who by divine right rules our empire. You're going to tell us what you're going to do. In fact, you're going to tell us that you're just going to take this whole thing, this as far as you saw the clips we played from the madness of King George. They understood the magnificence of North America. Hell, they had just fought a war as part of a 100-year war. They had just fought a war to take it from the frickin' French and to go into hock to do it, of which they were trying to undo being in hock by telling the colonies, hey, look, have a little something for the effort. It's, you guys are living there. You're getting the benefits from it. You got to throw something into the till. We need some money. We need some cash. We got to tax you. But the dispute really came down to who's in charge. And the British was telling you who's in charge. I got 300. They said it looked like a forest of masts out there. Think about how magnificent it did when we were there on Saturday. You had 50 or 60 tall ships from around the world. Look how stunning they look. That's 50. These had 300. And lots of them had cannon ready to be used to go up the Hudson and say, hey, we're going to cut this thing in two. We're going to cauterize Massachusetts because those guys are out of control. And we're going to have the more gentle people in Pennsylvania and in Virginia, in the middle Atlantic states. We can talk reason to them, and you keep these hotheads down south. They're out of the program anyway. Keep them out of it. We got this. It's called war. And if you're in Bowling Green, you realize, hey, I don't know what my carbon dating is, what my half-life's going to be. But I'm pretty sure it's not going to be long. That's your lineage. Read, now we're in the stage of the War of Independence. Read it. We get our ass kicked forever. Washington's strategy is very simple. Keep the army intact. Keep the army in being. If we can do that, we can drag it out. And eventually, if we don't quit, we win. Have you heard that before? If we don't quit, we win. This is exactly what's going on in Georgia and in Michigan. What the volunteers, the Caroline Jefferson, the Garland Favoritas, and all of it, against a establishment that's working against you. Let's just lay the cards on the table. Why is Pulte at DNI? Why does John Solomon have to leave Real America's Voice from the show that I've tossed to? And I'm quite honored on this channel. Think about it. The great honor I have had that at noon every day for years, I would toss to the Charlie Kirk and the Charlie Kirk Show. And then at 6 o'clock, you got John Solomon and Amanda Head, John Solomon. And John Solomon's now in the White House working. And everybody's saying it's unbelievable what's happening. Why is that happening? Why does it have to be a guy like Pulte and John Solomon? Why John Solomon? Why Gateway Pundit and Fani and Patty McMurray and 100? The 100, the sacred 100, the honored 100 in Michigan. They gave up their time, hours and hours and hours to go through 155,000 frickin' ballots multiple times to find 26,000 that are illegal. When you've been told, it's been rammed down your throat that you're a nutcase and you're fringe and this show's banned everywhere, deplatform, all of it. Like, I give a tinker's damn about that. Because I don't, because the show just gets bigger and bigger, because you know why? A lot of people want to know what's going on. And in Georgia, this is years and years and years, and they indict people, and they try to get them on felonies, and they bankrupt them. Was the Republican Party, did they ever come in and have your back? Did they ever come in and say, no, we can do this together? No, they worked against you. They worked against you, working against President Trump. John Thune and this crap, give me a break. Oh, we know if you do this, we don't do this, do this. He's got to be turfed out. You don't turf him out, you're going to lose the Senate. And this is even with Michigan and with Maine probably going our way. People just don't have the enthusiasm. They don't. Here's how I know they don't. The small dollar donations, which used to be voluminous everywhere, they've dried up like a creek during a drought. Why? The little guy's sitting there going, I've got to figure this thing out. Who's real and who's not real? Who's talk and who's action? Separate the wheat and the chaff, just like they did in the revolution. Do you think 90% of the people here in the continental United States were, hey, let's take England on. Let's take on the greatest, most powerful empire to that date in world history. Let's do it with the people to my left and right? No, it was not. It was a quite small number that fought, and there was a small number that supported. The rule of thumb was a third. A third. In New York City, which by September, I think basically was gone. So they're saying there on the 9th of July, they're reading the Declaration of War against the guy with a big, huge gold, lead statue covered in gold, looking like Caesar, right, in a triumph. Massive statue. They're looking up at that thing, and you're declaring war on that. And you look out there and you see 300 combat ships of the greatest navy in the history of the world, in world history. Some of its greater glory to come, but hey, from Francis Drake and those guys, they were pretty damn good where they were about to have enormous to beat Napoleon. And have Nelson at Trafalgar in the Nile take on the French Navy, take on the Spanish Navy, and kick their butts. That's what you're looking at. You got nothing. You don't even have any ships. You're a ragtag. You got a little Continental Army and a bunch of militia. You don't even know how to drill. The Poles haven't even shown up. They haven't shown us up how to march, how to drill, because when the fire starts, you got to be high and tight when the volleys start hitting. And the British Army knew how to hit you with a volley. When you're sitting there hearing that, one thing you understand, my days are numbered. My days are numbered. So what am I doing this for? That is the DNA. That's the spirit of liberty. With all the happy talk and all the balloons, all the fireworks, that's the real thing. That's the thing itself, as I call it. The thing itself lives. That's what's happened in Michigan with Patty McMurray and Fani and Jim Hoff and the team. That's what happened in Georgia. People who will not back down, who will never quit. And if we don't quit, we win.
Ms. Kirk, Good morning to you as well. First, with respect to courtroom protocol, to maintain security and decorum, any individual that exits the courtroom during proceedings will not be permitted to re-enter until recess. After recess, all counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and the still photographer. If both of you could please approach the lectern. The court's purpose in this dialogue is to ensure clarity regarding the expectations governing today's proceedings. Could you both please state your roles for today's hearing?
My role is to capture pool photography, still photos.
My role is for video in accordance with the court decorum order.
And I apologize. Would you mind putting your names on the record?
Tess Crowley.
Megan Thackeray with KSL.
Thank you. Have you both reviewed the court's standing decorum order?
Yes.
Yes.
Do you understand the requirements set forth in that order as it applies to your activities today?
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
No.
Do you anticipate any difficulty complying with the order?
No.
All right. Thank you both. Before we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone or electronic device in the courtroom may be addressed by the court. For those individuals who have a cell phone, I invite you to join me as I silence my cell phone to ensure that the proceedings today can proceed without distraction. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with this court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or of other visible reactions during the hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, and orderly, and faithful to the rights and dignity of every person involved. All right. My understanding is the parties wish to address an issue before we get started. Is that correct?
We may.
Mr. Novak.
Thank you, Your Honor, and good morning. I passed up to the court after providing copies of it to counsel for the state and counsel for the media, a single piece of paper. Does the court have that?
I do. Thank you, Mr. Novak.
Thank you, Your Honor. So every morning, this court has a colloquy with the camera operators about their ability to comply with this court's orders. And they acknowledge that they understand the order and that they can comply with it. And the court asks them if they have any problem with it, and they state to the court that they do not have a problem with it. We also spent many, many, many hours of court time addressing which exhibits will and will not be published through the electronic media. And this exhibit, the court ordered would not be published through the electronic media, and it was. And without belaboring the point, the court can imagine our concern that the media and the state who control this exhibit and the publication of this exhibit in the courtroom as per the court's orders failed to comply with this court's orders after all of the effort that we made and the court made to make sure that the court balanced everybody's rights, including the rights that we're concerned about, which are Mr. Robinson's. No doubt the counsel for the media and counsel for the state will say that it was a very, very brief mistake, that it was corrected as soon as they realized the error, but it's done. It's out there, it's photographed. I'm informed secondhand that if I want to buy this image and maybe even have it framed and put behind museum quality glass, I can do so and put it up in my office. Obviously, I'm not going to do that. But my point is, it doesn't matter how long the court's order was violated. When we live in an electronic world, it's done and it's permanent. And we just wanted the record to be clear that we're concerned that the court's orders have been violated, and they've been violated with respect to an order that was specifically designed to protect Mr. Robinson's right to a fair trial. And I don't want to belabor the point any further. I'm also not going to refer to the exhibit with any more specificity because it's not necessary.
Is there a requested remedy or potential sanction that you feel is warranted given the actions which you have outlined this morning?
I think that we would like to think, when I say we, I mean Mr. Robinson's counsel, about that. We have, as the court knows, repeatedly asked this court, moved this court, not to have electronic broadcast of this proceeding, of any of the proceedings, and specifically this proceeding. The court denied those motions and overruled our objections to the specific EMC requests. So I think it's a little premature, but I can represent to the court that we will suggest a remedy in advance of the next hearing.
Well, Mr. Novak, I appreciate that, but I would ask that if it is something that is concerning, that it be addressed immediately. So I'm not going to wait until this. I recognize and appreciate what you have described, and this was on my mind a lot last night as well.
Okay.
I don't want to sit on this. So I ask you respectfully to confer with your counsel and come up with that, because I want to address it. I agree. It is concerning, and it warrants examination and to be addressed immediately, especially as we have a little bit left of our preliminary hearing. So I want to give it the weight it is needed, and I don't disagree with you.
Then why don't we beg the court's indulgence? We don't need to empty the courtroom. We can go talk about what we think an appropriate measured sanction would be, and we can bring that suggestion back to the court in a few minutes.
All right. Well, before we do that, I want to turn to the state and to the media to address what you've addressed, and then obviously if there's a part two, then therefore to that.
And I appreciate the invitation, and I also appreciate the court's desire to address the consequences, if any, immediately.
Thank you, Mr.
I was not
Novak.
trying to delay it. I just think it's an issue which warrants some thought. The court has said it gave it some thought. We will have a suggestion very briefly.
Thank you. Turning to the state.
Thank you, Your Honor. I think at the outset it's important to recognize that everyone's doing their best here. The court is, I know the clerks are, I think the media is, we certainly are, and the defense is. This issue came up in the context of an examination of a witness. One exhibit was published before the exhibit at issue. was also brought onto the screen, I explained what we were going to do, and then the exhibit was brought onto the screen. I reviewed the video last night. The camera captured this for approximately 2 seconds. The camera operator, I think, acting in diligence and appropriateness, immediately panned as soon as she realized that there was a new exhibit on the screen. The court took it down. As soon as they realized that an exhibit was on the screen, I immediately instructed my paralegal to take it down, and it was. Defense, I think everyone involved here made quick and appropriate efforts as soon as they realized a mistake had been made to remedy and mitigate that issue. As I explained what I was what we were going to do, defense counsel did not object as that happened. And the reason I bring that up is because of the requirement for timely objections. Moreover, I do want to say this exhibit was read into the record. It was allowed to be read into the record earlier. It is also in an earlier pleading, which is the information. This portion of that exhibit, I understand, is in the information. And it is largely cumulative of Exhibit 16 and 16.1, which were previously admitted into evidence and published to the media. Finally, we are going to be dealing with a lot of publicity when it comes to media coverage, and I think that's really where the remedy is going to be addressed. I understand there may be a remedy that can be fashioned today to prevent this kind of thing going forward or going on in the future in this hearing, but I think ultimately that's where this will be addressed. Any other questions from me, Your Honor?
Well, not at this time. I will afford you the opportunity, obviously, to respond when defense comes back. I want to weigh this and taking in consideration, and I find your representations to be accurate as to what occurred. I believe that I noticed it and asked for it to be taken down because I have a live stream on my screen for that very purpose. And the sequence, I believe I made note, and if I'm wrong, please correct me. It's been a long 4 past days, but that's the only addition that I find to the representation. And certainly, Mr. Novak, feel free to correct it if you believe the sequence was any different. I just want to make sure a clear record is being made of what happened in order for whatever happens next to be appropriate and proportional to the actions that occurred.
No, and that's consistent with my memory, and I also reviewed the video, the live stream as well in preparation for this issue today. So that's exactly what I think happened. From my perspective, examining the witness, I did not have a view of what was being published to the public and the media, and so I think the court immediately, as soon as it recognized that, brought that to everyone's attention.
Thank you, Mr. McBride. To the media.
Good morning, Your Honor.
Good morning.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point. But here's how I understand them. There's 2 exhibits at issue. Those exhibits were used yesterday in part because the juxtaposition of those 2 exhibits might have provided some sort of benefit to the court. The first of those exhibits was asked to be published through all 3 of the court's phases. The court said it will be admitted into evidence, be shown in the courtroom, it will not be shown on the cameras. That happened about 3 hours into the hearing. That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the runtime yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that 3-step process. In that case, the court said that that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. Examination on that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit, and recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end of it. I think the 2 seconds is about right. I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire. And we are trying to place as many nets as we can, and all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live screen, someone can screenshot it, and like Mr. Novak said, if they want to put that for sale on the internet, then they can. That's why working together to ensure that even small mistakes like that don't happen is critical. And the media has the media coalition that are given the opportunity and the benefit of being able to be here to run cameras and to take photographs have complete buy-in on that point. There are, of course, people out there watching a live stream that are not part of our coalition that we can't control, and that's why it's so important that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word, of that exhibit is contained in a search warrant, in this case, that was initially filed on September 17th. This is in the 4th District, but in a different court. Was held for 6 months, as search warrants often are, but then on March 16th, March 17th, was released in full. On page 7 of that search warrant is the full text of this exhibit. I don't want to suggest that anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen, but since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for the purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image of the exhibit itself, but the full text is already in the public sphere, has been reported on, and is out there. I only want to reinforce, to close, the recognition that the media, our coalition, I, as an attorney for that coalition, have an obligation to make sure that mistakes don't get made. And in this case, even though I believe that the camera operator didn't act in violation of the court's decorum order, didn't do something that was forbidden by that there was an order that said, don't publish this exhibit. And because it flashed on the screen when the camera operator was filming that screen, that did happen. The media is fully bought in. I, as one of the attorneys and the other attorneys for the media coalition, are fully bought in on a goal to make sure that this kind of thing doesn't happen. Of course, I understand Mr. Novak and the defense's need to make a record and make an objection, and I also recognize and appreciate and understand the court's role in trying to make sure it imposes whatever sort of direction, caution, sanction, response that it believes is needed to make sure that its orders are recognized and adhered to. And I want the court to know that we will understand that and will comply with whatever it is that the court orders.
Thank you. Anything further before we break? Mr. Novak.
We don't need a break.
Okay. Well,
the court wants a break.
I want to review this. I'm sure there is a stream out there. I want to look at it again in order to appreciate the full effect and exposure. I remember it, but given the nature of this and trying to weigh the constitutional rights of all parties, I want to be thorough and look at it exactly. So as we move forward, as I evaluate what's being requested by the parties, that I am at the level of knowledge, and because for what it is, it was on screen. I want to look at it, how long, what exactly was on screen, and in order to be at the point of saying, okay, I fully understand. I mean, I was here, I saw it, I noticed it on the screen, but again, I want to take that extra 2 minutes to review that.
I'm not suggesting that we rush through this at all. I just wanted the court to understand that our request for the remedy and the sanction, we are prepared to share that with the court, but we can certainly wait until the court has had an opportunity to review whatever the court thinks it needs to review. The permanence of this violation of the court order is a different issue from how long it took to correct the violation. It's a permanent consequence. In other words, that image is out there forever and ever in violation of the court's order, no matter what actions the court, the state, and the media took to remedy it, because that's the technological world we live in. So that's my response, if I may, to the arguments. But we can hold our suggestion until the court's ready for it.
All right. If the parties feel it'd be helpful to confer while the court is reviewing it, you may, just so that if you choose to, I encourage it. If you don't, I respect that. A court's going to take about 5 minutes. Again, I just want to review it, to be brought up to full speed and just to have it freshly in my mind.
I'm going to make one more point, if I may, and that is this is not the first time that this has happened. We had earlier proceedings in this case where the cameras depicted images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion, if I may. Thank you.
All right, before the court takes a 5-minute recess and to review this, does any party need the benefit of the record based off the dialogue between me and Mr. Novak? All right, not seeing any party respond. The court's in recess. We'll come back at 9:45. Court is in a brief recess.
Donald Trump's desperation to silence voters and their deeply unpopular views of his presidency has hit an alarming and dangerous new low, with a new report about how Trump's MAGA media allies appear to be laying the groundwork for Trump to take control of this fall's midterm elections. Media Matters writes this. Quote, right-wing media figures such as Steve Bannon, John Solomon, and Cleta Mitchell appear to be weaving together a narrative about interference by China in U.S. elections to justify a national emergency to curtail voting rights. Here's an alarming sample of that. Watch.
If they can't cheat, they can't win, correct? You agree with that?
100%.
The reason he ain't there and Pulte is to get to the bottom of the 2020 stolen election.
Stop talking about the SAFE Act and do a national security emergency for elections.
But also Pulte, this is why they're trying to stop him at DNI. Why the firestorm to stop him and to shut down Solomon? Because if you want to have an executive order that could withstand an immediate court challenge and be overturned, you have to lay out a pretty definitive predicate for that.
And you heard the name there a few times, Bill Pulte, suggesting that Trump's newly installed acting DNI is heavily involved in this plan. Media Matters writes this, quote, the main players here come not only from the fever swamp backwaters of MAGA media, but also from the Office of the Director of National Intelligence and the White House. How MAGA media is laying the groundwork for it just by having the discourse about it.
Yeah, and look, I mean, we should also keep in mind here that it's not, the people that were outside trying to overturn the 2020 election are now inside the administration actively helping to disrupt and sort of thwart it. So a lot of this is through a lens of not just what they're saying on the outside, but how it's working in tandem with these official positions. So people on the outside are now running a task force, as you noted, Bill Pulte, who's now the DNI, and the storytellers have kind of signaled what he's there to do, which is to help sort of be part of this sort of three-part sequence. One is to manufacture a predicate, sort of create the evidence. They're not going to try to find it. They're going to manufacture something. Then the thing that they seem to be centering around is this idea that China interfered in the 2020 election, and they're going to sort of uncover by declassifying a whole bunch of what is supposed intelligence that reinforces and improves that. So that's the first thing, manufacture the predicate. The second then would be to use that to declare a national emergency And then the third part of it is to impose by decree what they haven't been able to get passed legislatively, or what has been sort of pushed back in the courts to these with these executive orders. So that is parts of the SAVE Act, and to try to further thwart and disrupt the election. And that's it. And they are echoing it on the outside. They're signaling all of what they're planning to do, and they're beginning to move the machinery into official parts of government to actually execute it.
Put it this way, Jack Smith is not someone prone to hyperbole. And exactly 24 hours and 10 minutes ago on this program, on this station, he told Nicole Wallace that he is very concerned about the midterm elections and the integrity of those elections, not because of external threats, but because the internal apparatus of our government is actually, as Angelo just said, participating in laying the predicate for creating those fears. And I want to be very clear about one legal aspect of this, Eamon, which is to say, you just saying that there's an emergency is not some talismanic thing that you can wave that invokes all sorts of other powers. There are emergency powers and statutes that grant emergency powers, but they are specific statutes. So there's a National Emergencies Act. It does not mention elections. There's IEPA. That's the statute that Donald Trump tried to use to impose the global tariffs. And when the Supreme Court considered that, it noted the word tariffs isn't in there, the word tax isn't in there. Well, you know what else isn't in there? Elections, which is to say that in order to invoke emergency powers, you need to have congressional statutory authorization. So to Angelo's point, forming the predicate, what he referred to as step one, is absolutely their plan. Step two is where they are legally flawed, even beyond getting to step three. But to your point, what they're trying to do will not be legal and will not be something that the law authorizes, but the executive can almost always outrun the courts. That's the problem. So they can succeed in this even if they fail legally by creating the fear, by taking the action, and then it's almost too late.
And letting the courts catch up. I mean, they have the ability. They have the ability to shape their reality on the ground, and letting the courts play catch up through the various proceedings.
They can outrun the law and then turn around and say, well, it's easier to ask for forgiveness than permission.
Yeah, absolutely. Angelo, the reporting mentions that Bannon's podcast colleague, John Solomon, who NBC News reports is part of a team gathering thousands of intel documents to give Trump an opportunity to amplify new accusations about past elections. And we're seeing this dangerously play out in a state like Georgia as well. What do we know about the relationship between the White House and the ODNI and podcasters like John Solomon?
I mean, that's the question here, right? Because let's keep in mind, they've been signaling what Bill Pulte is there to do, which is to get to the bottom of this, to be a participant in this. What Solomon's task force is supposedly designed to do is to declassify documents, to uncover intelligence that proves that the 2020 election was stolen or manipulated by China, in particular, is what they seem to be settling on. And so some things happened in the last 24 hours from the DNI, where they started to fire career intelligence officials, analysts, for withholding information. Now, what information are they claiming that they've been withholding? We have no idea. They haven't said anything about it. But it certainly lines up with the types of activities that Solomon is designed to get to the bottom of or help expose. The very people that would be identifying this internally or saying, hey, there's no evidence to back this up, are the types of people that they've been purging from the DNI's office and the intelligence community in the last 24 hours. So this is part of the synergy. And the last thing I'll just note, because this is the part that I find really revealing. There was a qualified director of national intelligence that was appointed by Trump, and his nomination was ultimately withheld to get confirmed so that he could put this acting DNI in place, Bill Pulte, whose only qualification seems to be that he knows how to weaponize government offices for political purposes. And Bannon has been saying all along that he's their guy to help execute this. So that there's an intense synergy here where the storytelling, the media apparatus is beginning to sync up with these government entities. Something that was, a podcasting is now operating under a presidential seal. And that's it. They're almost one and the same.
Legally, Bill Pulte has a lot of power as an acting DNI and not necessarily a ton of accountability. So to Angelo's point and to their point, Melissa was pointing out that because of the way the process works with DNI, he can effectively be acting for as long as they need him, and certainly can be acting through the midterms. But every lawyer learns one thing in their first year of law school in the constitutional law class. Angelo certainly learned this. That is, in April of 1952, Harry Truman tried to seize the steel mills. And what was his basis? Well, the Korean War and a pending strike that could have yielded a serious shortage of steel, serious national security implications. What did the court say? Justice Jackson wrote an opinion, one of the most famous opinions for evaluating presidential exercises of power. That there are three categories, a sliding scale. And when the president is acting inconsistently with the express will of Congress, by the way, Congress has repeatedly, as you know, rejected the Save America Act. That's what they're trying to do by using emergency powers. That is where presidential power is at its lowest ebb. So, is it possible they can outrun the courts? Yes. But will it be illegal and unconstitutional in every way if they try? Yes. And so we don't want to give up hope that the courts and the people can stop.
War Room. Here's your host, Stephen K. Bannon.
Today is the final day for the preliminary hearing that will decide if Tyler Robinson will stand trial. He is the man accused of shooting and killing conservative activist Charlie Kirk last year. Yesterday, prosecutors played a taped interview with Robinson's former roommate, who said that Robinson admitted to the murder to him.
Prosecution. And he introduced himself in this sworn interview, and he said that they had met in about 2023 and they became roommates. They didn't know each other, but he said in 2 to 3 months they started dating, and so they had known each other for about 2 years. And he said on the morning of what is now known as the shooting that Tyler Robinson said he had to get going very early to work. 4 or 5 a.m. is when he left. And remember, they live in St. George. This was in Orem, so it was over 4-hour drive. He also said that he didn't talk to him until 11 p.m. that night, but the next morning is when they arrived back. He arrived back at the home, and that's when he actually saw him. That would be the 11th. He describes what he heard and what he saw from Tyler Robinson when he arrived back to their apartment. Watch.
Did you and he ever talk about politics?
He did more than me. I don't really keep up with politics very much. He'd usually talk about stuff he heard on the radio on his drive to work in like their work car, since it sounds like their whole crew went in the same car most of the time. But I wouldn't say super consistently, because it wasn't a topic I really contributed much on.
What about Charlie Kirk? Did you ever talk about Charlie Kirk?
I personally had never heard him talk about Charlie Kirk before specifically.
Okay. How about political issues? So did you ever talk about gender identity issues and LGBTQ rights?
No, not really. Usually if he did talk about politics stuff, it was relating to Trump or current policies being issued or voted on, I think.
So that right there, that's interesting. He never spoke about Charlie Kirk. Now we've got some texts that we want to show you, because they texted a lot right after the shooting happened. He said, "You weren't the one who did this, right?" "I am. I'm sorry." "Why did I do it?" "Yeah. Well, I'd had enough of this hatred. Some hate cannot be negotiated out." Now, when he got back to the apartment on the 11th, what Lance Twiggs, who said that was his name, he said that he was nervous. Tyler Robinson, he was walking around the apartment. He started to cry. He said he didn't know why he did this. And he said he wished he hadn't done this. But this is there was no cross-examination of, you can't cross-examine a recorded statement, right. But there was a witness on the stand too. The defense didn't touch it. And this is very challenging because this is someone who is very close to Tyler Robinson, who has turned and become a prosecution witness.
Hello, War Room Posse. Hey, I can't be with you the next few days, so I wanted to get on here and tell you I'm going to extend that sale that only comes once every 250 years, the Made in the USA sale. That's right, our premium My Pillows, king size only $19.98, lowest price in history. Queen size $18.98, standard $14.98. We have our My Pillow mattresses, the best mattresses you'll ever sleep on, 50% off. And by the way, the whole order ships for free right to your front door. Mattress toppers as low as $99.98. Then we have the bolster pillows, the body pillows, the go anywhere pillows, all of it on sale. Go to mypillow.com/war room. You're going to see another sale that collides with that, the Mega 2 sale. And then you're going to find the Giza Dream Sheets as low as $29.98. Our 6-piece My Towel sets, $39.98. You have kitchen towel sets on sale. You have everything for the kitchen, bedroom, bathroom, everywhere. Promo code WARROOM. Free shipping on your entire order. You guys call 800-873-1062. Use the best promo code in history, promo code WARROOM.